July 1st, 2021, and ask the Commission Secretary for information on today's agenda.
Each commissioner has independently reviewed the minutes of the open meeting of Thursday, June 24th, 2021, and each has informed me there's no need to discuss those minutes.
Move we approve the minutes of Thursday, June 24th, 2021.
Second.
All in favor?
Aye.
Each commissioner has independently reviewed the agenda, and each has informed me there's no need to discuss the notices associated with agenda items 2 through 37, the draft final decision closing docket 4910 WI 101 associated with agenda item 38, the suggested minute associated with agenda item 39, accepting the reports of Wisconsin electric providers and aggregators. The Division of Energy Regulation and Analysis is directed to inform each electric provider of its compliance with the statute. Or the suggested minute associated with agenda item 40, approving the draft final decision in docket 6630 EA 153 and modifying delegated item 76 to delegate authority to the administrator and deputy administrator for the Division of Energy Regulation and Analysis to issue orders for utility applications for abandonment of electric and gas facilities that require a hearing because potential customers affected by the proposed action have failed to respond to the utility and have not otherwise affirmatively objected to the action.
Move we approve the notices of investigation associated with agenda items 2 through 33.
Second.
All in favor?
Aye.
Aye. Move we approve the notices of proceeding associated with agenda items 34 through 36.
Second.
All in favor? Aye. Aye. I move we approve the notice of rescission associated with agenda item 37.
Second.
All in favor? Aye. Aye. For agenda item 38, I move we approve the draft final decision in docket 4910 WI 101.
Second.
All in favor?
Aye.
Aye. Agenda item 39, I move that we accept the reports of the Wisconsin electric providers and aggregators regarding compliance year 2020 for Wisconsin Statute 196-378-2A2 and direct the Division of Energy Regulation and Analysis to inform each provider of its compliance.
Second.
All in favor?
Aye.
Aye. Agenda item 40, that the Commission approve the draft final decision and delegate to the Division Administrator for the Division of Energy Regulation and Analysis to issue orders for utility applications for abandonment of electric and gas facilities that require a hearing because potential customers affected by the proposed action have failed to respond to the utility and have not otherwise affirmatively objected to the action.
Second.
All in favor?
Aye.
Aye. Okay. That takes us to our next agenda item, which is agenda item 41. This is docket 5-146, Parliamentary Creek docket, where on September 26, 2019, the Commission served the final decision granting with conditions a certificate of public convenience and necessity, authorizing the project's applicants, ATC, ITC, and Dairyland, to construct the project. On June 21st, 2021, ATC and ITC requested that the Commission rescind the final decision granting the CPCN for the project and reopen docket 5-CE-146 to consider next steps. Dairyland filed a letter supporting ATC and ITC's requests. The Commission has additionally received a number of responses to those filings. Needless to say, the applicant's requests are really unique. I cannot recall any prior examples where the recipient of a CPCN has requested that a final decision granting its CPCN be rescinded. My inclination is to issue a notice of intent to rescind the final decision and request comments. I would accept comments on the application request for rescission and on any other action that the Commission should take in response to the applicant's requests, including what the next steps would be. I appreciate that we've already received some comments, but I think providing an opportunity and an orderly process and a deadline for comments to come in would be beneficial. So to that end, I would suggest that initial comments in response to our notice be filed by July 16th of 2021, and that any reply comments be filed by July 23rd, 2021. Commissioner Nowak? Thank you. Yes, this is an unusual request, but I think given the circumstances that keep surrounding this case in several venues in court, I think it is appropriate and a reasonable request on behalf of the applicants here. And as you note, we did receive some filings late yesterday, and at least I got some additional ones this morning. They are addressing both the rescission and the reopening that was requested by the applicants. I think it's noteworthy that at least the primary plaintiffs in one of the lawsuits has also, I think, my interpretation, agreed that there should be a rescission of the CPCN. And I want to note that I think that it is an appropriate action to take under the law. We have to give notice and an opportunity to be heard before that a final action can be taken. And then I do think that we would benefit from some more comments, particularly on what is the next steps following that action. But I also think it's imperative to note that by doing this, we are in no way conceding anything that has been alleged, anything about us, about our former colleague, about this institution. There's been a lot of, I think, allegations thrown around. And just like you and I don't prejudge anything, I'm going to ask that all the parties and members of the public also not prejudge anything before all the facts are known. So I am prepared to move forward. Like you, I'm also prepared. I think we should reopen technically the docket as well for the limited purpose of seeking those comments as well. That under the law doesn't need any particular notice as well. So I think that can take effect as today. We effectively reopen the docket. We issue a notice of intent to rescind. I was a little shorter on the timeline, but we're not too far apart on, because I have a hunch that there's parties know where they're going to be at on this issue. And like I said, to me, the biggest thing is the next steps. And the next steps, to me, we have to ensure that process is done, but process also doesn't mean undue delay in moving this forward. This case has been present since 2018. I'm not sure what more can be said about this, but there is always more information. But I think we need to move this along very quickly and in a fair manner for all the parties, and revisit this as a body. So I was at the 12th, that Monday, so we're not that far apart on questions. And you want reply comments as well? I do. I think just given the unique nature of the filing, I mean, in 20 years, I can't recall this ever happening where a certificate has been issued. Right. And the holder has asked for us essentially to take it back. Right. So I think, and sometimes what we see when comments are filed is that people are talking past each other. Right. Because they're coming in simultaneously. Right. Which is why I thought reply comments would help us. Would you then be willing to move up the initial comments then to a little earlier than if we do reply comments, just so things are wrapped up a little sooner? So would you keep? I would do the 12th for initial and then maybe reply by close of business on that 16th or even the 19th. I can do, I think 12th and 19th. Yeah, sure. That way that's done. And right. So initial comments, we would issue a notice of intent to rescind and to reopen the docket for the sole purpose of collecting the comments. Yeah, we reopen this docket, well, for the purpose of, the comments and the issue of rescission. Right, yeah, right, yeah, the reopener. And I just want to make it clear that I would welcome comments on any path. Yeah. So if a party thinks that they've come up with a reading of the statute and they think that we should take steps A, B, C, they should put that in their comments. Yeah, no, we haven't done this before. Right. So I think that, I think we're going to see comments that run the gamut on how long this should take. And like I said, we've read the record. And so, I will be honest that I don't believe that we need to have a whole new record re-entered. I think there needs to be some updating, if necessary, to some of the information that's come in, but I don't see a need for us to go through everything that you and I have already received and has been received in evidence and verified by the witnesses. None of that has been called into question, so to me there's no reason to duplicate all that work and have all that unnecessary time and expense on behalf of the parties for everyone involved. So, before we go, I want to make just a quick comment about the open meeting and open records. I've been in public service for almost 18 years and have a high respect for being in public service and following the law. And we take an oath for this job. I've taken an oath now 3 times for my appointment. I respect that very much. And we don't talk to each other. We talk to each other about dogs, maybe about your kids, and when your mom passed away. So people don't understand that, but it's true. And I just implore again the public to understand we are a unique body here in the state of Wisconsin. And, maybe it's just, I have so much respect for being being in public service, and I really take my oath very seriously, and as I know you do, and Commissioner Huebner, although you're recused from this case. But so I wanted to say that. So I think that, we're both at reopening, issuing a notice of intent to rescind, initial comments, reply comments, and we can take that up and hopefully get a process moving soon. Right. Okay. So the one thing I want to be narrow about is I'm not saying today that I think it should be reopened, that the case should be reopened. I'm saying I think we should issue a notice of our intent, get the comments back, and then we'll come back, talk about all the comments we've received. I don't know if that's a procedural question, if we have to reopen the docket to receive those comments on the record. I think it gives, the reason, there's no downside to doing it. I went back and forth, but to me there's no downside to reopening because if we're saying the scope of what we're reopening for, it gives us some more flexibility, and we don't have to then bring it up at a separate special meeting or whatnot. We can close it when we need to. It serves as a repository for the information coming in input. So to me, there was no downside to reopening this, at least for the purposes of considering this decision and what we're going to do here. I think it's the right step to start to make this move because it is a 2-part question, right? It's not a both and, it's an either or we can do them together. So I just want to make sure that that's clear. That we're not legally required to reopen the docket. Well, I think I'm not sure that it's a prerequisite, but I think it is. I think it's the appropriate step here. What I do know is reading 19639, we don't have to give prior notice to it. That's why I think it can be effective today, which I think is an important step to take today to do that. There is no downside to doing it. We're going to be reviewing this docket in some form later. Might as well reopen it. Okay.
And excuse me, Commissioner, just so I'm clear, you are indicating though that the reopener at this point in time is limited to the first step, and then the commission would come back to the second step?
Well, the rescission. Which is a big it's a big thing. So, right. Yeah. Yes.
It's not for the purposes of receiving evidence regarding the modeling and et cetera, like that.
So it's limited to
Yeah.
the comments that we just set the schedule for.
Yeah, I don't want comments about land use or where a
Right.
pool should be or whatnot, that stuff. The purpose right now, once we rescind, should we do that whenever, then we'll take that broader step. But it's I think it should be reopened to consider these comments.
Yeah, and I think we're saying the same thing.
Yeah, I know.
Just, I just want to make it clear that we're not reopening the docket to, as the applicants put it in their request, consider next steps. That's not why we're reopening the docket. We're opening the docket because we're issuing a notice of intent where we're seeking comments. I don't want to hear about environmental. I don't want to hear about the cost of battery storage. I don't want to hear about, what's happening in Texas.
Yeah, but you want to hear about what should our procedural steps be.
Yes.
Yeah, those
Yes.
next steps.
Exactly.
Yeah. Right.
And I think that was reflected in many of the comments that we received. Was, whoa, you can't do anything. That's not how we do things anyways.
Right.
We're very deliberate. So the first step is to issue this notice of intent to rescind. And I can agree with opening a very limited reopener for the purpose of receiving the comments related to procedural next steps.
Yeah.
Okay.
Yeah.
Clear?
Yeah, I understand.
Okay.
So I'll move that.
I will second that. All in favor?
Aye.
Aye.
Not the recusal.
So I would like to note that Commissioner Huebner is recused from this decision. I didn't know if you wanted to make that clear, but I will make it clear.
Yep.
This case is a part of your official recusal policy, which is why you're not participating
Correct.
in this part.
Yep, and I'll abstain from the vote.
Okay. All in favor?
We did that, but aye. Yeah.
Aye. Oh, jeez. Okay. All right. So, the next item on our agenda is a closed session item. We are going to recess our open meeting to go into closed session under Wisconsin statute section 19.85 sub 1 sub G to discuss the litigation matters noted on agenda items 42 and 43 with our legal counsel, and we will then reconvene the open meeting pursuant to statute.
Move we go into close pursuant to Wisconsin statute 1985 sub 1 sub G.
Second.
All in favor?
Aye.
Aye.